My name is Bob Olson, and I have the privilege today of introducing, that one doesn't work. Oh, it does now? Yeah. Okay. Great. Of introducing the panelists for the next session, which is titled Regulating the Big Firms. Now, it takes a big brain to comprehend Dodd-Frank's provisions regulating the big firms, and today we're privileged to have three big brains who, in addition, are distinguished legal scholars and teachers as described in the programs that you all have copies of. And we're going to follow the same format as in the first session. That is to say, we're going to have devote about an hour to the presentations, and then we'll have hopefully about a half hour for Q&A. Again, I'm supposed to, and I will, remind those who are on the webcast that the email address for questions is corporatelawsymposium@law.uc.edu. Okay, now we're going to start with our first panelist, who is Onnig Dombalagian, who is George Denegre Professor of Law at Tulane University School of Law.
Thank you very much. I want to thank, obviously, Professor Black for inviting me to participate, and the University of Cincinnati College of Law and the Corporate Law Center for sponsoring this symposium, and my special thanks to Professor Olson for reading my paper, a bloated monstrosity perhaps as long as the Volcker Rule, and not necessarily any more substantive. My topic is the Volcker Rule. I call the paper Proprietary Trading, Scourge, Scapegoat, and Scofflaw. I was watching the Ken Burns documentary on prohibition a few months ago, I guess, when it was airing. And maybe it's just alliteration, but the Volstead Act and the Volcker Rule just got me to think about the juxtaposition of a rule with a high moral purpose that is very difficult to implement and perhaps practically impossible to enforce. So one might say, again, not to draw out the analogy too much, but we can all get a sense for what the purpose of the Volcker Rule was. I mean, there was a sense that proprietary trading was somehow responsible. Proprietary trading by the large financial conglomerates that we've been speaking of was somehow causally linked to the financial crisis that we've just experienced. And the question is what to do about it. Well, we have a very high-minded prohibition that we'll talk about, right? We will restrict proprietary trading by banks and their affiliates. So one question to ask is, is proprietary trading really the scourge that deserved this kind of, statutory restriction or statutory prohibition, or was it somehow scapegoated in light of other abuses like securitization, improper underwriting standards, inadequate capital, and so forth? And then I toss in the word scofflaw, right, which is kind of the prohibition-era term for kind of the flagrancy with which people defied the mandate of the 18th Amendment. Commentators are divided as to whether or not they think the Volcker Rule is going to be effective. The New York Times, two of their respected legal bloggers, one of them says, again, it's a bloated and weak monstrosity that's as good as dead on arrival. The other one says it's going to restore the old divide between investment banks and commercial banks, as if, Glass-Steagall risen from the dead. And there are signs both ways, right? There are regulators who are making noises. The commissioners on the SEC and even senior SEC staff members have made noises that there will be additional rounds of rulemaking, following the initial one that I'll speak to briefly. At the same time, many banks have signaled that they might be thinking about spinning off their investment banking arms. Many prominent traders at these firms have left before the ship ostensibly sinks. To go work for hedge funds and so forth. So it's not really clear what's going to happen. There is suspicion that this rule will be on the chopping block if and when a majority more sympathetic to the banking industry takes over Congress or the White House. So none of us really know what's going to happen. It's kind of living in that same state of flux that maybe the 18th Amendment lived in. And so I won't torture the analogy any further, but talk about the perspective with which I'm going to try to approach this. I'm not a banking lawyer. I'm a securities lawyer who did a lot of work with investment banking and then worked at the SEC. So I'm looking at it from the trading perspective. To what extent does this rule regulate trading activity appropriately, inappropriately, and more importantly, from the perspective of a regulator, when given a mandate like this, which has a clear purpose but is difficult to execute, what do you do? So the basic outline of the talk will proceed something as follows. We'll talk about some of the reasons why we think proprietary trading might be to blame for the financial crisis. We'll talk about the Volcker Rule and its relationship to Glass-Steagall, which preceded it, and Dodd-Frank, of which it's a part, but just one part. I'll talk briefly about some of the difficulties, or actually quite a bit about some of the difficulties with the proposed implementation of the Volcker Rule in the first round of rulemaking. And then at the end, I'll throw in a few ideas that I'm tinkering with about how one can achieve the rebalancing of incentives that Paul Volcker envisioned. To start off with, it's probably worth telling you what the Volcker Rule is. So the operative provision is fairly straightforward, unless otherwise provided, and I left out a lot of the stuff you can go look up. A banking entity shall not engage in proprietary trading or acquire, retain any equity partnership or other ownership interest in or sponsor a hedge fund or private equity fund, essentially indirect proprietary trading through a fund. So it covers banking entities, which are essentially all the affiliates that Professor Brown showed you in the financial holding companies that we have today. So to the extent of a broker-dealer that's affiliated with a depository institution, or swap dealers, or asset management, all the other entities that could be affiliated as part of a financial holding company. They are all banking entities to the extent they're controlled by the ultimate holding company parent. The other definitions are a little more arcane, right? I mean, what is proprietary trading? Well, is it any trading? No, it's engaging as a principal for the trading account of a banking entity in a transaction to purchase or sell certain financial instruments. And here the list is fairly long: securities, derivatives, futures contracts, options on any of those, and anything else the regulators think is a covered financial contract. Trading account then raises the question, what do you mean by trading as a principal in a trading account? Well, here we're talking about accounts used for acquiring or taking positions principally for the purpose. So already now we have to figure out what the purpose, how one tests purpose. Purpose of selling in the near term, or otherwise with the intent to resell in order to profit from short-term price movements. So there is good proprietary trading, presumably, which is motivated by things other than profiting from short-term price movements, other than short-term transactions. And there is bad proprietary trading, and all we have to do is distinguish the two, and we've achieved the objectives of the rule. Well, of course, that would be too straightforward. So now we have various activities that are deemed to be sufficiently socially desirable, and they are socially desirable activities. But the question is, to what extent are regulators going to interpret these safe harbors broadly or narrowly? So the statute says that the regulators shall, through rulemaking, build out these safe harbors for certain activities that will be permitted, notwithstanding the general prohibition of the Volcker Rule. These would include, among other things, trading in U.S. government agency and municipal securities, because obviously the ability to hawk U.S. national debt is more important than any regulatory system. Oddly, not foreign sovereign debt, much to the consternation of many foreign sovereigns who would like to make sure that banks can continue to deal in their debt. Underwriting or market-making related activities for the near-term needs of customers. Obviously, if you want issuers to be able to raise capital in capital markets, and if you want people to be able to trade these securities in secondary markets, you need underwriting and market making out there. To the extent that the largest banks, are the only ones with the balance sheets that can sustain that kind of trading activity, we have to carve out some sort of safe harbor for them. Risk mitigating hedging activities. You should be allowed to trade to mitigate the risks in your other permitted lines of business, including, for example, interest rate risk and currency risk associated with traditional banking business. Agency and brokerage, to the extent that you act for the account of others, that's not considered proprietary trading. Trading is a principle for your own account. You can see that there are specific safe harbors for state-regulated insurance. So insurance business that's subject to adequate state regulation, as Professor Brown talked about, that's carved out of this prohibition against proprietary trading. Securitization, oddly, one might think that securitization was one of the major factors that led to the financial crisis, but that's also carved out. And then, sponsorship of funds, certain activities, of qualified foreign banking organizations, and so forth. All of this, again, qualified by what you might call the three major policy prescriptions of the Volcker Act. No material conflicts of interest with clients, customers, or counterparties, no material exposure to high-risk assets or trading strategies, and no threats to the safety and soundness of a banking entity or to the financial stability of the United States. So you can think about those statutory limitations as essentially setting out the parameters of the policy behind the Volcker Rule. Right? To the extent that we believe that proprietary trading by banks exacerbates moral hazard, they're playing with depositors' money, which in turn is backed by the FDIC. Or even if you're not a depository institution, to the extent that Goldman Sachs, Morgan Stanley, others were AIG were able to draw either from the FISC or from the Fed during the financial crisis. We don't want that kind of implicit financial assistance to be backing essentially high-risk trading, highly profitable but high-risk trading by banks. We've also heard about the conflicts of interest, right? When a broker or a dealer sells you a security, they're not selling it to you necessarily because they think it's in your best interest. They're selling it because somebody is pushing that security. That's how corporations raise money. That's how capital formation is done. But this creates conflicts of interest. And so, you can look at the problem from the perspective of shareholders of financial institutions, where you have traders playing with other people's money. You can look at it from the perspective of customers and clients of the firm who are being sold products that might be inappropriate, that are opaque, difficult to value, and often are accompanied by a high markup. But there are conflicts of interest throughout this business. To what extent can you avoid them? I mean, underwriting and market making pose significant conflicts of interest, and yet they're part of the core business that of financial entities. And then you might also make the argument that proprietary trading destabilizes markets. I mean, to the extent that over-the-counter derivatives traded in a pretty much opaque market, you really had no idea what gross exposures were, you had no idea what indirect exposures were. In the absence of centralized clearing, you could discover that somebody that you had done no business with was the ultimate counterparty to all your transactions. That kind of trading activity can destabilize markets. To the extent that one thinks about things like the flash crash, is there excessive volatility in equity markets or exchange markets? One can also associate that with this general aversion to proprietary trading. So we can think of a variety of reasons why we might attribute a part of the financial crisis to proprietary trading. But again, one can cite other factors: excessive reliance on short-term borrowing, lack of liquidity, inadequate capital. One can look at the size of securitization, the lack of underwriting standards behind securitization. Are those the causes of the financial crisis, and proprietary trading is just sort of a related factor? Or does the Volcker Rule strike at the core of the financial crisis? This is something that commentators debate. In context, how does the Volcker Rule differ from what preceded? Well, Glass-Steagall famously erected this barrier between commercial banking and investment banking, but it did so in a way that lent itself to, either you can view it as abuse or laxity, or you can view it as compromise over time. Glass-Steagall barred affiliations and certain personnel interlocks between banking, banks that have insured deposits, depository institutions, and any entity engaged principally in the issue, flotation, underwriting, public sale, or distribution of securities, what we think of as the investment banking business. The key phrase there is engaged principally, right? This is like banning intoxicated liquors, and then you just have to figure out what intoxicating liquors means. Is it 2% alcohol? Is it 20% alcohol? What is engaged principally, right? So over time, that phrase is interpreted to permit banks to engage through their affiliates in increasing amounts of securities activity, both qualitatively in terms of what kinds of activities may be permitted, and quantitatively in terms of the cap on gross revenues before you run afoul of the prohibition. And many people felt that Glass-Steagall had basically been rendered a nullity before Gramm-Leach-Bliley was adopted because of the Fed's liberalization of the rules. You can also look at Gramm-Leach-Bliley's approach, which was to essentially segregate businesses, right? You can do brokerage, you can do dealing, but you have to do it through a separate affiliate. So we will structurally segregate the different businesses. That way, if the broker-dealer goes under, the entire, the rest of the family survives. And then Dodd-Frank, also has other provisions that are designed to address some of these policy objectives. There are a lot of provisions that others have talked about that deal with the problem of moral hazard, higher capital requirements, higher margin requirements, leverage limitations. We'll talk about OLA in a few moments. There are prohibitions, there are restrictions on certain kinds of conflicts of interest. And there is extensive regulation of trading markets, as I think one of the afternoon panelists will speak about. So what have the regulators done? Well, they have to take this mandate and translate it into rules that are enforceable. Well, first of all, you have to define what some of these terms mean. It's fairly straightforward to define what a banking entity is because there's a statutory definition of the bank holding company that pretty much tells you how you should construe that term. But terms like trading account, market-making related activities, risk mitigating hedging activities could lend themselves to broader interpretation. Now the question is at what cost? If you start redefining trading accounts, suddenly you're creating opportunities for people to arbitrage existing capital rules, which turn on where trading assets can be held. How do you define market making? The agencies have proposed to define it by reference to fees relative to risk, revenue relative to risk, or do most of your fees, your revenue come from fees, or does it come from spreads? How volatile is your revenue? With whom are you trading? Are you trading with customers, or are you trading with other banks? All of these, are questions that somebody has to answer because, you could define market-making related activities to mean everything, just like you could define speculation as hedging-related activities, right? I mean, it's all about what the breadth of the term, what the term encompasses. To enforce the rule, we have a set of quantitative metrics that are designed to monitor some of these numbers. So, how much risk are you taking on? To what extent is the risk predictable kind of risk? To what extent is it are profits volatile? These might be signs, for example, of market making of proprietary trading in the speculative sense, as opposed to market making in the kind of routinely collecting a spread on trading sense. And then we have a set of compliance and enforcement procedures. The banks themselves, depending on certain inflection points, $1 billion and then $5 billion in assets are the two principal inflection points, will have to adopt a series of internal compliance procedures. How regulators will supervise these is not clear. I mean, we know that the principal sanction for violating the Volcker Rule is that the regulators will tell you to stop the activity and not do it again. So you could imagine that this could be like, the guy in my first slide. Every time you find a stash of alcohol, you go smash it, take a picture, and then, the activity moves somewhere else. Or you could imagine that, the regulators will, be more proactive in terms of, investigating and detecting this kind of activity. It all depends on the resources that are allocated. One problem is that you have agencies like the SEC and the CFTC whose mandate is not safety and soundness of the banking system, regulating entities that are subject to the Volcker Rule. To what extent should the SEC, as regulator of brokers, looking out for the interests of brokerage customers, supposed to regulate the activity of a broker-dealer subsidiary of a bank holding company for purposes of complying with the Volcker Rule prohibitions? Moreover, to the extent that agencies like the SEC don't necessarily have the wherewithal to engage in the kind of sustained supervision presence at the banks, looking at the kind of risk they're taking on, as opposed to periodically going in and inspecting to make sure that the internal controls are kept up to date and that activity is being appropriately dealt with. To what extent can we rely on agencies like the SEC and the CFTC to enforce this prohibition? If not, that leads to a risk of differential enforcement. I mean, we know the Fed's incentives. We talked a bit about the risk that they might be inclined to be a little more lax at the front end on the theory they can always bail people out at the back end. One can say from the SEC's perspective, to the extent that their primary tools are enforcement actions, to what extent are they willing to use that cudgel to enforce the Volcker Act prohibitions? Since I have about a minute and a half left to throw out my ideas, my fear is that what the regulators are going to do as they go through multiple rounds of regulation is try to define more specifically some of these terms, like market making or risk mitigation. And in doing so, that creates a danger that through persistent lobbying, we might be able to expand the scope of some of these safe harbors unnecessarily. So what I'm thinking about is, finding a way to construe the Volcker Rule purposively. I mean, to the extent that it's living in this state of uncertainty, what can we do with the Volcker Rule now to make or to affect improvements in proprietary trading? And my sense is, breaking up the cartel is essentially what we're all trying to get at in one way or another, right? Post-Gramm-Leach-Bliley, there was a huge consolidation of the financial services industry. Is it possible to reverse that process? My suggestions, as outlined on the chart, is it possible, for example, to create more competition in proprietary trading or more competition in market making and underwriting by, for example, easing out some of the investment banking departments from the commercial banks, restoring some of the former investment banks as non-bank financial companies, creating opportunities for new entrants, maybe larger hedge funds that want to engage in market making and so forth, to break up the cartel of control over proprietary trading. The way you can do that is first by creating incentives for spin-offs and for new participants. Another way is to take the SEC's authority and the CFTC's authority under Title VII to create markets that actually give a leg up to non-banks or that give a leg up to smaller market participants to compete, either by being able to quote more aggressively or to take precedence perhaps over banks, or to have other rules that enable customers to interact with their quotes and requests for quote. And then finally, one of the things I'm thinking about is tying the Volcker Rule metrics to the competitiveness of the markets in which they trade. If you can create metrics that, rather than try to define abstractly what market making is, try to coerce people to trade on open exchanges, open clearing houses, to make sure that end users are protected by clearing systems, to make sure that the markets in which they compete are fair, that have an abundance of competition and aggressive quotation of prices and aggressive trading. That's a better way to try to achieve the purposes of the rule rather than abstract hypothesizing over what the safe harbors mean. So I'm 1 minute over, but that's my presentation, and I look forward to your reactions.
Thank you very much, Onnig. Our next presenter is Stephen Lubben, who is Harvey Washington Wiley Chair in Corporate Governance and Business Ethics at Seton Hall University School of Law.
Hey, you guys have my new title, and I still have my old title on the slide, so you're more up to speed than I am. So what my purpose, my role is to talk about two things. First, about living wills, and second, about orderly liquidation authority, and they kind of go hand in hand. Because, the living will plans for your orderly liquidation later on. Now, rather than talk about it in the direct sense of just marching you through the rules, I actually decided to engage in kind of the exercise of putting not a hypothetical, but an actual financial institution through orderly liquidation authority to see how that would play out. This is in some sense kind of the parallel to an exercise the FDIC has done. They put out a paper indicating how Lehman Brothers would have been resolved under their new orderly liquidation authority, and I'll have some thoughts on that later, but FDIC and I have gone back and forth with competing columns in the New York Times about this issue. They didn't like my first column, let's put it that way. So the entity that I choose is Bank of America. They'll be so happy. So this is a slide actually that comes from one of their recent corporate presentations about all the places where they have dominant market positions. And I'll leave it up there while I tell you a little bit about Bank of America, the entity that we're going to put through orderly liquidation authority. At the end of 2010, in their 2010 10K, they reported having assets of $2.3 trillion. That's trillion with a T. That represents, to give you some context, almost 16% of U.S. GDP in Bank of America. They hold $2.2 trillion of client assets in their broker-dealer part and $1 trillion of deposits in the bank part. And they have more than 2,000 subsidiaries worldwide, formed in 97 different jurisdictions around the world. And their companies operate in 163 different cities around the world, based on my count at the little chart at the back of the 10K. About 31% of the companies are operated from locations outside of the United States. Obviously, the biggest single location outside of the U.S. is London, 150 subsidiaries operating in London. Domestically, and this is going to be important when we get to the resolution piece of this, Bank of America includes, as best as I can figure out, 12 insurance companies, 6 FDIC-insured banks, and 4 broker-dealers. This is all under the North Carolina Holding Company. So, again, 12 insurance companies, 6 banks, insured banks, and 4 broker-dealers. And you see here's all the places where they operate. And again, it's throughout the world. And the 2,000 subsidiaries, most of them are in London, most of them are in places you would expect. But then you do have head scratchers. I mentioned last night at dinner, they have 6 subsidiaries in Paraguay. I really don't know what the 6 subsidiaries in Paraguay are doing. I'm not sure even the CEO knows what the 6 subsidiaries in Paraguay are doing, but there you have it. So that's kind of the corporate picture. The next thing to look at is their financial structure. So their financial structure, is typical of financial institutions in that it's about 90% debt and 10% equity. So fairly heavily leveraged. And I think what's important, this is why I picked this particular slide here, is to think about how much of, and again, this is typical of a financial institution, how much of that debt piece is short-term borrowing. $420 billion of short-term borrowing. That is comprised of $250 billion of repo transactions that they are engaged in, and $50 billion of money market funds. And they actually say in their 10K, if their money market credit rating goes down, it could have a material effect on their cost of capital and their business operations, which is important because, as Jennifer pointed out this morning, there is an article in the New York Times about how Bank of America might be about to be downgraded on the credit rating. So more news to come from them. So they also, I guess the thing I would point out about the short-term borrowings, and probably also foreign deposits too, right, is these are the things that we're going to be especially concerned about once you have the onset of financial distress, because it's going to be those pieces of their capital structure that might go away quite quickly and need to be replaced through what, at least in bankruptcy terms, would be called like DIP financing, right? Some sort of liquidity loan from some new source. Because the commercial paper they might not be able to roll over anymore, the repo they might not be able to roll over anymore, and the foreign deposits might kind of leave because they're typically not insured right by the FDIC, so that's not going to be quite as stable as well. In addition to all this, Bank of America has the second largest derivatives portfolio in the United States, based on their filings with the OCC. They have a total derivatives book of just over $74 trillion. That's a notional amount. The only one bigger is Chase at $78 trillion. So a very large derivatives portfolio. 48 trillion of that is held at the insured bank level. The remainder is actually in London, which is also going to be important for when we try to apply this orderly liquidation thing to the bank. So then I think let me talk a little bit about some law. Before we get to orderly liquidation authority, I think it's probably useful to go through the exercise of just thinking about how a large modern financial institution would go into insolvency in the absence of orderly liquidation authority, which is important for two reasons. First of all, it shows us how OLA has changed the picture, but it also, I think it's important to remember that orderly liquidation authority under Dodd-Frank has to be invoked. If it's not invoked by the regulators, this would still be the system that would apply then. So if you have a kind of a situation where they decide a particular financial institution is not worthy of OLA or is not going to cause a systemic problem, then you would basically have to resolve it under this system. So basically, right, the bank here, the banks, being the depository FDIC insured banks, will be resolved under an FDIC receivership. The insurance company, again, as was talked about in the first panel, is subject to state regulation. That's going to be a state court receivership. The broker-dealer pieces will be a SEPA liquidation proceeding. Typically, that'll be referred to the bankruptcy judge, maybe even the same bankruptcy judge that is handling the bankruptcy of the parent company. We see that in Lehman Brothers, where the same Judge Peck has both the parent company and the SEPA proceeding. The financial holding company, and I'm using that term, as a term of art used under Graham Bleach Lively, the financial holding company at the top, in Bank of America's case, the holding company that is, headquartered in North Carolina, but it's a Delaware holding company, that would be subject, I'm assuming, to Chapter 11. Again, wherever I say Chapter 11, it could also be Chapter 7, but for a big corporation, even if you're liquidating, usually you pick Chapter 11. And also, essentially, everything else goes into Chapter 11. This is the sort of the status quo prior to Dodd-Frank, and again, the system that would work if Dodd-Frank OLA was not invoked. So how does it change? Well, when you invoke Dodd-Frank's OLA, it changes a lot less than you might think, right? Because one approach might have been to create an OLA, an orderly liquidation authority, that encompassed the entire financial institution, right? It would seem to make sense to get past this sort of fractured regulatory structure that we have in the United States, and that continues into insolvency, and try to have one forum, right, to resolve the entire financial institution. But they didn't go that route. So, right, the FDIC still is going to be doing a separate bank receivership for the insured banks. Insurance companies are expressly carved out of OLA, like they are carved out of most of Dodd-Frank. So they would also be subject to state court receiverships. The broker-dealer is subject to a kind of modified SIPA proceeding. And I'll explain that, come back to that in a second. The financial holding company is subject to OLA directly, and the everything else bit of it would be subject to OLA directly. So the primary changes, right, is we've replaced Chapter 11 with orderly liquidation authority here for the holding company and for other non-regulated subsidiaries. The two big regulated pieces of the financial institution are subject to the same old process they were subject to before. Now, the broker-dealer thing is a little interesting, because if you read through Dodd-Frank Title II the first time, you might think that broker-dealer liquidations are also carved out of this process, but they're really not. In this respect, the FDIC, who's going to be the receiver under any OLA proceeding, has the power to move broker-dealer assets along with other assets into a bridge bank. Essentially, this bridge bank process is a sale to a newly created corporation, really not unlike what happened in like the GM bankruptcy, right? Where you take the good assets that you want to keep, you move them into a new entity through a quick sale. It'll be an even quicker sale under OLA, as I'll talk about in a second. But it's basically that same structure that they used in the GM bankruptcy. So FDIC is going to have the power to take assets out of the broker-dealer, put it into the bridge bank. Then, and only then, does the normal broker-dealer liquidation process proceed. So it's a broker-dealer liquidation consisting of like the remnant bits that were left behind, which means it's not going to be quite exactly the same. So let's talk a little bit more about the specifics of the details of OLA before I get into its application to Bank of America. The process of orderly liquidation authority is triggered through this very complicated tripartite initiation process, which actually this morning I was reminded of sounds a little bit like the process for bailing out a bank in the UK, in the sense that 3 regulators have to agree simultaneously to invoke OLA. So they apparently may have learned the wrong lesson from the UK process. Basically, right, if depending on what the financial institution's primary purpose is, which could be a little vague in some cases, 3 regulators are going to have to agree to invoke OLA. So in the case of a depository bank, it would be the Treasury Secretary, 2/3 of the Federal Reserve Board, and the 2/3 of the FDIC board would all have to vote to put a financial institution into OLA. If you get into an investment bank, the SEC subs in for the FDIC, and there's a similar thing for insurance companies where the new federal director of insurance would sub in for FDIC. But in all cases, it's going to be the Treasury Secretary and the Fed board that's going to be voting to put the entity into OLA. If they do that, the OLA process is invoked unless the DC District Court says no within 24 hours. If the DC District Court either approves or does nothing in 24 hours, it automatically, OLA is off and running. And in that case, what happens is that the FDIC gets appointed as receiver for, again, the bits up here that I've indicated. So basically the holding company, the non-regulated subsidiaries, and part of the broker-dealer, basically whatever part they want to keep. And I mentioned earlier about this transfer to the bridge bank. One reason why they will probably want to do the transfer to the bridge bank is that OLA, unlike the bankruptcy code, has a 24-hour stop on termination of derivative contracts. So under the normal rules of bankruptcy, a counterparty to a derivative can terminate upon your bankruptcy filing. So this is, again, a reverse of the normal rules of bankruptcy where these so-called ipso facto clauses are not enforceable. They are enforceable with regard to derivatives, but then they're, again, not enforceable for 24 hours under OLA. So again, what the FDIC upon appointment will probably want to do is move within that 24-hour period at least the entire derivatives book of the financial institution to the bridge bank to basically stop anybody from terminating. Now, the thing I should point out, though, is, and this is important especially with regard to Bank of America, and kind of transition us into the specifics of Bank of America, is OLA is expressly limited to the domestic piece of the financial institution. So in the case of transferring Bank of America's derivatives book to a bridge bank, you would only be transferring the domestic piece. And again, there's a very sizable chunk of that that's actually in London. So that will be left behind. And in fact, I would observe at this point that in many respects, actually, Chapter 11 is probably better suited to dealing with an international business than OLA is. Because we have actually specific examples of foreign corporations filing for Chapter 11 in New York. And so in theory, you could put the entire financial institution into some sort of bankruptcy process in New York. Again, home state regulators might have some objections to trying to do that with regard to a financial institution. But certainly with a real economy corporation, it happens all the time. Whereas OLA is expressly just limited to the domestic stuff, so you don't even have that option. All right, so I have 5 minutes left. Let me tell you quickly how this would play out then. This is the speedy version of this. Bank of America, OLA is invoked. I'm assuming it's invoked. Immediately what happens, right, is we have several basically partitionings of the corporation. Right, so first of all, Bank of America, OLA is invoked. Probably that's going to also trigger state insurance receiverships in several different states, right, for all the insurance company subsidiaries. You're also going to have 6 FDIC bank receiverships that are triggered. At least 4 SIPA proceedings will be triggered, right? And right then any unregulated bits go into OLA. Almost immediately, you will also then have a separation of the foreign part of Bank of America from the domestic part, because that's just the way the OLA works. Now, I have concerns about this because in Lehman Brothers in particular, when this separation happened, especially with regard to London, my understanding is that the London operation, which was substantial, was immediately cut off from Lehman's computer system. So Lehman Brothers London no longer had access to its own books and records. Which makes it kind of difficult to operate at that point. So there's that. So we've got this nice big separation. I assume what FDIC is going to do almost immediately is try to take the good parts of Bank of America and put it into the bridge bank. Now the good parts is probably going to have to include the entire derivatives portfolio, whether good or bad, because they only have 24 hours. And also Dodd-Frank requires that you take all derivatives with one single counterparty. So there's no ability to pick and choose there. So I think probably all derivatives go into the bridge bank and the good assets. Can that be done? Well, this is where we get back to the living wills. Currently, I doubt that you can figure out which of those 2,000 subsidiaries have the good assets and which don't. So that's going to be a very messy separation currently. Now, the living wills process might improve that. The living wills process might also, right, improve the foreign versus domestic separation, but this is going to require the regulators to be, serious about requiring living wills that, specify how the bank pulls apart in these ways. And then, basically think about what you've got left here now, right? You've got good bank in a bridge bank, and you've got basically the bad remnants, right? And the FDIC has got to basically resolve both pieces there. At the same time, FDIC is also instructed to fire all the senior management, which may, depending on how deep that cut goes, right, could make this process a little difficult. And the good bank, right, their standard model is to sell, right, you create a bridge bank and you sell it to somebody else. They don't usually reorganize that themselves. But the question is there anybody who can buy Bank of America, right? Probably not. It would definitely require a waiver of concentration limits, right? Because Bank of America is over that already. So there's that problem. So you have this very, the big question mark, can the FDIC do this? Now, the alternative, and I'll just conclude with this, would be to use some sort of bankruptcy process, and this has been suggested. The big problem with using the regular bankruptcy process strikes me as funding. If you go back to that pie chart I had up there before, remember that Bank of America has liquidity needs of something like $400 billion. Right? The biggest private dip loan that was ever made was $8 billion, and that was in Lyondell Chemical. And I actually have here, right, the entire dip market, right? Well, the 10 largest dip loans in 2011 totaled $3 billion, and 1/3 of that were dip loans that were made by Bank of America themselves. So that becomes a little problematic. So basically, right, while I think there are serious problems with OLA, I also really doubt the ability of the bankruptcy system to work this solution either. So I'll end there.
Thank you, Stephen. Next up is Jennifer Taub, Associate Professor of Law, Vermont Law School.
So I think we can see a trend from my panelists, what I've learned so far is that the ban on proprietary trading set out in the Volcker Rule, Section 619 of Dodd-Frank, won't really be a ban on proprietary trading, even if we can define what it means. Then we've heard that the orderly liquidation authority provided under Title II may not result in an orderly liquidation at all, emphasis on disorderly. So I suppose you can see what's next as I will address the financial stability related provisions of the Dodd-Frank Act, my premise being that so far those provisions have not actually promoted financial stability. And so the question becomes, is that a fault of the statute, or is it a fault of implementation? And if we look at the second answer, is it that implementation was weak and ineffective, or that it's been delayed and there's still some hope for the future? Before I begin to answer those questions, I want to go back to something that Professor Black said this morning, that it's become a campaign issue to call for the repeal of the Dodd-Frank Act, and that many folks are saying that Dodd-Frank is and I'm quoting, a major impediment to economic growth. I find this a stunning overstatement in that I don't believe Dodd-Frank has even been a major impediment to bank growth. So that brings me to my first slide. I thought if I was going to try to argue that the 4 years after the run on Bear Stearns that kicked off the 6 months that then peaked in the failure of Lehman and so on, here we are 4 years later. What are the data points if we want to see whether the financial system is more stable or we have ended too big to fail? So if we look at some conditions that were in place prior to the crisis and ask, are they still existent? If you take a look at bank size and concentration, to the extent that we believe bank size and concentration is connected to too big to fail and too big to manage institutions, let's take a look. Before the crisis, bank size, the top 5 banks' assets relative to the gross domestic product were 50%. And today, this is based on Richard Fisher of the Dallas Fed's data from mid-year of 2011. Today, the top 5 had assets equal to 58% of GDP. I'm not a mathematician, but I do know 58 is a bigger number than 50. We look at the share of industry assets. Back in 2005, and this comes from the FCIC report, the top 10 had a 55% share of industry assets. Now we see that the top 10 have 65%. And then the top 5 are now at the 52. So we have greater size and concentration. What about repo? Professor Lubben mentioned repo as being, that's repurchase agreements, which is a source of short-term, often overnight funding for banks. The data that he provided indicated that Bank of America has about $250 billion of repurchase agreements. Repurchase agreements, as a quick refresher, are essentially where a cash-rich investor provides cash to an investment bank, for example, collateralized by, it could either be U.S. Treasuries, or it could be mortgage-backed securities or equity, really any type of collateral. This market was about $4.27 trillion at the peak in 2008. Now it's about it was 4.27, now it's gone down to 2.7. However, it's still a problem. The Federal Reserve Bank of New York has put out a white paper. Many other observers understand the great risk that is presented if a large dealer, if there was a run on repo. That's what happened at Bear Stearns. This is where your short-term funding is pulled by your counterparties who don't trust trust the numbers you're putting out there, don't trust your financial stability. So right now we can see that half is overnight. What's also more disturbing, though, is sort of the second line I have up here on collateral quality, because the type of collateral that is now backing these repos are not the safer type, the more risky type is now increasing again. To emphasize beyond creating instability. Remember, this is in the shadow banking world or in the investment banking world, instead of relying entirely on deposits to fund your loans or to fund the assets you put out, they're depending upon the shadow banking system, the securities markets, to get this funding. So that is inherently a risk. If this is overnight money, that can be just pulled and not renewed. But what also we've learned about repo is it becomes a source for masking and hiding debt. So you might remember that, right around the time that Bear Stearns was privately rescued with $30 billion worth of Fed support, was a time when Henry Paulson was asking the other banks and investment banks to shore up their balance sheet, and Lehman had a conference call where they said we're much more liquid and we're much less leveraged, which was true on paper because they were using something called Repo 105. They were treating their repo loans as if they were sales. After that came out through the bankruptcy report, the Volcker report, we then found out that other giant banks were not necessarily engaging in that practice. They weren't treating repo loans as sales to shrink their debt outstanding, but they were actually they were recognizing the fact that they could hide their debt by reducing their repo outstanding just before the quarter end. And so when the snapshot was taken, it made them appear less leveraged. So I'll go back to the figure Professor Lubben gave us, which was to say Bank of America says it has about, I guess it was 200, roughly did you say, 250 billion of repo outstanding. Who knows what they really have? It's not daily averages. The Fed has access to that, but they don't have to report a daily average repo figure. That's just the snapshot. We don't really know how risky they are at the moment. So what's another condition? Leverage, generally. So when I'm talking about leverage here and I'm looking at the conditions, I'm talking about the difference between what a financial institution owns and what it owes. And I'm looking at a true Tier 1 equity to total consolidated asset figure. Before the crisis, the requirement for bank holding companies was about 3 to 4%. What that means is for every $100 of assets that they owned, they could borrow up to $97 to $100, just or 100 billion assets. You can borrow $97 billion. Today, those rules have not changed. There is, both in Basel as well as Dodd-Frank, it's about 3 to 4%. There are supposed to be enhanced leverage requirements, but those have not yet been announced for the largest, the bank holding companies with over 50 billion in assets. As for shadow banks, prior to the crisis, if you were not a regulated entity, there was no restriction on the amount of leverage you could have. So if you were one of the independent investment banks, at least at the holding company level, there was no restriction. As for today, and in addition to that, if you look at the industrial loan firms like the GECCs and so on, or the GE Capital and so on, they are supposed to, and also insurance companies, are supposed to be brought in as these non-bank systemically important financial institutions. Since none have been designated yet, and there have been no rules promulgated yet, there are no restrictions there. What does this mean? Safe levels, people vary. Former chair of the FDIC, Sheila Bair, recently said that heading into the financial crisis, it was those banks that had 12 to 1 debt to equity ratios, which would be greater than 8%, was what she thought were the ones that survived and didn't need help. So our baseline is too low in terms of equity cushions. Anad Admati, who's a professor at Stanford, also Simon Johnson at MIT, have put out 15 to 20% as a reasonable equity cushion. Now let's just think about this when we look at homeowners. We used to say that you should put 20% down when you bought a house. We recognize that going to 15, 10, 5, 0% down made little sense. Homeowners would be considered unwise. It would be imprudential to put down 3 to 4%. Similarly, if you look at Reg T in terms of margin trading for ordinary investors, initial margin's 50%. So these figures that we are saying that, first of all, they haven't changed in terms of the permitted leverage, but they're just too high, or the equity is too low. So you might say, well, these are interesting figures, but you notice that there was a big announcement that the banks, except for a few, passed their stress tests. And these, the stress tests, just in short, really were not that stressful. You can look at what they were measuring. There's a report. It's easy to read and quite interesting. They were asking, they had the 19 largest banks test based on a baseline and a stress scenario going forward for 25 months. And the Fed had its own figures. It had a baseline and a stress, and each bank then could also come up with their own baseline and stress. And this was based on macroeconomic variables. So they're looking at a number of variables, but including things like assumptions about increased unemployment, or assumptions about other external factors like that. What some commentators have noted, and they were saying basically it was a capital plan. So the bank would say, if these scenarios hit, the stress scenario hits me, I plan to issue this amount of dividends, I still believe I have enough of an equity cushion. What they were looking at for their equity cushion was a Tier 1 common risk-weighted capital ratio of 5%. I'm underlining risk-weighted because what that does not mean, it was not saying 5% it wasn't saying that you could borrow up to 95% for every $100. They weren't treating every asset at its whole value. These were risk-weighted assets. So the 5% is not apples to apples to a non-risk-weighted ratio. But at any rate, one commentator noticed, looking at this, that on September 12, 2008, Lehman had 11%. So this, and if you look at all the 19, only 3 were above 10. So passing, I like to think of this, the no child left behind. This is the no bank left behind test. A few did fail, but nevertheless. So what are some big gaps? Besides this risk-weighted issue, some of the big gaps in the stress test include valuation. Blogreave-Smith noticed that one of these issues that keeps coming up is how banks are valuing their assets. The Fed does not go in and ask you, it does not value your assets for you. So things like second liens on these giant banks' books apparently are being held at 80 to 90% face value, even when the first liens are underwater. And their paper for these second liens apparently are trading at 30%. So the stress test is relying upon the financial models, again, for valuing these assets, especially the so-called illiquid or hard-to-value assets. We're back to where we were before. The last piece that was most telling, the more I kept reading and reading the report over and over again and trying to see, but it seemed, this was an issue before, a year ago when they did a similar test, not the exact same one, but it seemed like they weren't looking at a liquidity crisis. In other words, this issue, the thing that triggered the financial crisis was the run on the banks by the banking system when no one wanted to roll over the repo credit at Bear Stearns, or the problem at Lehman with repo. And so you say, wouldn't it make sense if you were having a stress test to try to test the scenario of what happens if there's liquidity problems? That's not part of this test. And I'll get to liquidity later, but it's not explicitly stated, but there's this line in the report that makes clear that the projection does not make explicit behavioral assumptions about the possible actions of creditors. That's translating to this does not actually reflect the reality of what would happen in a crisis. How did this happen? Here's a little flashback. If you were watching closely in late June of 2010, when the conference committee was getting together to hammer out the differences between the House and Senate bills for financial reform, and this was a televised conference committee, which was interesting. You can still go back on C-SPAN and watch it. Sort of in the mid-afternoon on a Thursday, which later became an all-nighter, Barney Frank, who was head of the House Financial Services Committee, made a funny comment. He's good for funny comments. And he said, okay, the cartoons are over. We're about to get into the double feature. A little bit of an inside joke for folks following it. The double feature was the Volcker Rule and derivatives. Those were the two big, most contested pieces at that point on the legislation. So what I cared about at that time, and still do, isn't the double feature, but what was on the cutting room floor. And so I'm going to talk about very quickly what could have been, because this goes to the question, is the problem in the statute or is the problem in the implementation? There were other options. This was not the only way. I'll go through, everyone knows what reinstating Glass-Steagall means, so let me just quickly go through the Safe Banking Act and the ending repo bankruptcy safe harbors, and then tell us where we actually are in the statute and where implementation is. So the Safe Banking Act, introduced by Senators Brown and Kaufman, would actually have created structural change. It would have made banks smaller. Within 1 year of the enactment of the statute, if this had gotten in, a bank holding company, its non-deposit liability, so this is that piece we're talking about that's not from insured deposits, would be capped at 2% of GDP. And so that would be $280 billion. And that obviously would result, and then for the shadow banks, it would be 3%. Similarly, it had a higher leverage ratio than ended up in the statute, minimum of 16%, and so that would be about a 16.66 to 1 ratio, still higher than what we saw Sheila Bair said was good, but a bigger equity cushion than where we would have ended up. This lost. There was actually a floor vote. What's interesting is Senator Dodd voted against, but there was one Republican for, and that was Senator Shelby, who was the ranking member on the Banking Committee. What would have happened if this had passed a year later? So, we would be talking about now how last summer, so a year after, the 9 largest banks would have been impacted. Citi, JP Morgan Chase, and Bank of America, for example, would have had to downsize by roughly 4%. The leverage cap would have resulted in affecting about 20 institutions. They would have had to either shrink their balance sheets, by shrink their assets because they're financed through debt, or raise $300 billion in new capital, or some combination of that. The other thing that didn't make it in, something that Professor Lubben has written about, and I believe worked with Senator Nelson on this, was a bankruptcy reform amendment. And what this would have done is, not just with derivatives, but with these repurchase agreements, ending the special treatment that counterparties receive in bankruptcy. The thinking would be, in terms of preventative measures, these institutions wouldn't be able to load up on short-term financing because the counterparties would be concerned that they wouldn't be able to break those either overnight or short-term repo contracts and either take the collateral or take the money back. And the thought would be it would prevent some of this short-term funding. You might note that even though Professor Lubben mentioned that there is a 1-day hold period, but remember that not every giant bank will end up in the OLA. If the 3 keys aren't turned magically, there still will be Chapter 11 bankruptcy, so this still does matter. So what the statute provided instead were, instead of structural change to substantially decrease size and leverage and deal with liquidity, it really left quite a bit to the regulators. In terms of dealing with shadow banks, the idea would be that with a 2/3 vote of this new Financial Stability Oversight Council, we would now have banks, former shadow banks now subject to Fed supervision. The problem with the statute itself, though, is it's not all shadow banks. It's limited to those that have 85% or more of their business in either or assets in the financial sector. 121 seems very promising. That section allows, with the 2/3 FSOC vote, to mitigate a grave threat, which means it's not really clear because the words grave threat are not defined anywhere in the statutes or the regulations, and it's not clear if you listen to Tom Onnig, who's former president of the Kansas City Fed and was just now yesterday nominated or approved by the Senate to join the FDIC board. He'll say no one's going to use that. The regulators, the regulators already have a similar authority under the Bank Holding Company Act and have never used it for large banks. The leverage cap, I'm going to skip over 165 and 166 for a moment. There is a leverage cap for grave threat companies, so you can get up to 6.6% if you propose a grave threat. It seems kind of, and you have 6 months to do so. Again, even for grave threats, that's too small of an equity cushion. If you look at 165 and 166, this is really where all the action is, all the power to prevent so that we don't result in having to try an untested orderly liquidation. All this power resides in the Fed in 165 and 166, but none of those rules for creating enhanced prudential standards or early remediation. This would be requiring one of these bank holding companies, the shadow banks, to downsize in some way, or not give out a dividend, or there are all these steps they can take. None of that has been enacted. The rules were just recently proposed, and comments are due at the end of April. However, if you take a peek at that, it relies on a series of triggers that indicate whether the firm that's being reviewed is having problems. Those triggers appear to, they're sort of too little and too late in terms of what the trigger is. It entirely focuses on capital, but those capital triggers, again, as I've started out by saying, I think it's too low nevertheless. There's also liquidity. The best thing about it in the proposals is they're looking to at the question of liquidity and short-term debt risk, but again, these are only proposals. Where do we go? The sequel. I think many of these ideas are being reproposed. In the presidential campaign, it was quite interesting to see John Huntsman came up with this new idea to downsize the banks relative to GDP. It's odd that this was only about 18 months ago, and very few reporters caught on to the fact that this was actually a Democratic proposal prior to that. You still hear last week the Dallas Fed put out its annual report with a very strong statement that unless we end too big to fail and downsize these banks, the economy cannot recover. So I think there is a sequel that is building, and we'll just have to stay tuned.
Thank you very much, Jennifer, and thank you to all three of you panelists for very stimulating presentations. Before I open up the session to questions, two things. One, we have a microphone which can be brought around to anyone who wishes to ask a question or offer a comment. And if you use the microphone, you eliminate the risk that I'm going to mangle your question or comment when I attempt to rephrase it for the webcast, okay? Second thing, I'm going to exercise the power of the microphone that I have and ask the first question for any one of these three panelists, and that is, yes? That is that I would observe that Dodd-Frank certainly dumps a huge implementation responsibility onto the various federal agencies that need to administer it. And, apart from, the influence of politics, lobbying, or just lack of agency resolve that might enter into the fray, I'd ask whether, what the opinions of our panelists are as to whether these regulatory agencies have the firepower or the resources, either human or financial, really to get through all the rulemaking that's required, and then to administer and to enforce the rules that ultimately emerge. We're here, 2 years after adoption, and there's still a long ways to go. So, anyone want to tackle that?
Well, I can actually start with one piece of that, and that is the implementation of OLA. Right, if the FDIC were to try to either liquidate or recapitalize a large financial institution like Bank of America, you would think they would need a much bigger staff than they currently have. On the other hand, they have this problem that you would have to basically, right, this is kind of the Maytag repairman problem, that these people would sit around for a long time until you actually needed them. But I mean, there is, I think, a real concern here, because my understanding is the FDIC is actually reducing its staff now that the number of bank failures has fallen off a bit in the past year. So if anything, they're going to have a smaller staff to deal with one of these things if they do hit. So, I mean, that's part of the practical concerns about orderly liquidation authority is it feasible that FDIC will be able to replicate what Weil, Gottschall, and Alvarez and Marcel and these other firms have done in Lehman, remembering that Bank of America and the other big banking companies are about 3 times the size of Lehman Brothers.
And one of the issues from both the perspective of the Volcker Rule and some of the other rulemaking in Dodd-Frank, a lot of it has to be jointly done. So, for example, the Volcker Rule is quadripartite, I guess might be the right word. It's the Fed, the Treasury, via OCC, the SEC, and the CFTC, because the rules are supposed to apply uniformly to all banking entities, and depending on the functions of a particular banking entity, it could be regulated by a different functional regulator. You see that throughout. For example, in connection with Title VII, there are certain aspects of the definitions of what is a swap or what is a security-based swap that have to be done jointly. I mean, to my mind, I remember when I was involved in joint rulemaking exercises, it was not nearly as productive as the agencies seem to be this time around. I think they're all on the same page at the outset, or at least they're all close to being on the same page at the outset. This could become problematic down the road. For example, if there are changes that need to be made, and as a result of shifts in the political winds or changes in the composition of some of the agencies, you do have differences of opinion that make it difficult to hammer out compromises. But in terms of volume, I mean, certainly I'm most familiar with the SEC, and they are trading in markets is under a ton of rulemaking mandates, and there's just no getting around it. But the joint rulemaking makes it that much more difficult.
So I really admire the regulators. I think they have a tough job ahead of them. I mean, they're under fire in every possible way. Appropriation threats of being cut. Professor Black mentioned the courts. This threat, the proxy access rule was the first rule promulgated under Dodd-Frank. It happened to be in the pipeline, and it was struck down by the D.C. Circuit. They know they're up against, sort of through their lobbying process during implementation, they understand that even if they compromise and do what SIFMA or industry wants, they're still going to be subject to litigation. So I think it's difficult. I think if you look at something like the Volcker Rule, what they're facing right now is this pressure to repropose the entire rule. And so the question is, will they repropose? It's going to be late no matter what, but will they repropose from scratch, or will they take what they have, even though there's something that everybody's unhappy with some part of it? And so it's a very difficult place they're in, and so I admire their work, even if I criticize the results.
Okay, sir.
Thank you. Your panel has really scared me. And by that I mean, in a sustained bull market, usually the financial sector leads the way in most cases. And last year, the Bank of America had the worst record in the Dow Jones averages. This year, it's up about 100%. It's trading close, well, it reached 10 in the last week from around 5. My practical question is, would you buy Bank of America?
Stephen, that's yours.
As it would happen, my daughter recently inherited some Bank of America stock, and we sold it the next day.
I have a question. We heard today about the big firms, but can we talk a minute about regulating the smaller firms? Because my theory is, because of the complexity and the cost of all of these regulations on the smaller firms, all we're going to have left are bigger firms. And we also talked this morning on the first panel about regulators closing their eyes to some of the things that the big firms were doing. My experience is the regulators don't close their eyes to the smaller firms. And what I've seen is that those regulations, again, have a tremendous cost and complexity in compliance with those smaller firms. And that's why I don't think we're going to have smaller firms. What we're going to have left with will just be the big firms.
I certainly agree. One of the things that I didn't talk about in the presentation but discuss in the paper is that the bigger you are, the more places you can hide your trading activity. Now, in the way the rules are structured, in theory, the more onerous aspects of the rule, for example, the compliance programs, the more onerous statistics kick in when you hit certain inflection points, like $1 billion and $5 billion. So on their face, the rules look like they put more burdens on the larger firms, but you're absolutely right. Smaller firms will have to comply with the restrictions just as well as the big firms. They will have to have the compliance controls that are required now under existing law. And to the extent that it's easier for the bigger firms to cause different divisions to absorb certain kinds of trading activity to meet certain quantitative metrics, or to the extent that you can hedge risks across affiliates, particularly since the Collins Amendment requires that you push out certain risks to your affiliates if you're a depository institution. There's just so much more room for evading the regulators. So my fear, and part of the motivation behind my thesis, was that we need to figure out a way to break up this cartel and let some smaller entrants into market making. And one way to do that is to think about how you can tie the Volcker Rule to market dynamics.
To address that, both in terms of the way back when in the legislative process and now in implementation, the lobbying organization for the community bankers, I think it's Community Bankers Association, was vocally supporting requiring the large banks to pre-fund the orderly liquidation fund, right? So this would have been assessments based on your size that would have paid for that. What we have now, if you want to call orderly liquidation a funeral, we have actually the taxpayers who Treasury's line of credit pre-funding the funeral. And if the assets aren't enough to pay back that line of credit, then there might be an ex post assessment on the largest banks. We'll see. I wonder whether that would happen given the financial conditions of those banks at the time. But again, the community bankers wanted that. But as you might remember, that was probably one of the most contentious issues, and that was what Congressman Boehner was describing as a taxpayer-funded bailout. So if you have banks fund in advance their liquidations, that's taxpayer funded. As soon as that dropped out, the legislation really moved forward. In terms of now, the stuff I was talking about, by not imposing, 4 years later we don't have enhanced prudential standards. The idea that a bank holding company has the same equity capital requirement as a small regional bank with, under $1 billion in assets doesn't make sense. Right, and so these things should be, the kinds of risks you're taking and your size and complexity should result in substantially higher equity cushions. And it's not, the question is, why is that not happening? I think it's it's the pressure, it's the money and politics issue.
One of the major things that Dodd-Frank does for people who are in the derivatives market is require them to post margin, and so I was wondering what protects the margin. It almost is explicit in some of the paperwork we've gotten in our institution that it is explicitly unprotected. That's in the disclosure that's right before the signature page.
Yeah, I mean, I think one of the ways you can protect the margin, right, is to use third-party holding of the margin. But then that also creates this whole issue that Bank of New York becomes, because they're holding most of the margin in most of these trades, as I understand it, Bank of New York then becomes the ultimate too-big-to-fail institution, because if they fail, they've got everybody else's stuff when they do fail. The working out the whole margin central clearing issue is still an ongoing process, and I certainly have heard complaints, too, that in some cases, especially CFTC has proposed regulations that would actually expose people to even more counterparty risk, especially if CFTC is requiring you to do central clearing and not do third-party margining. So it is still a huge mess.
Sure.
Also, it appears that the CFTC is regulating Dodd-Frank, but the SEC is regulating the broker-dealer, and we're dealing with the broker-dealer. So I was just wondering how this would all work. If the CFTC saw something dangerous that the broker-dealer is doing, would they tug on the sleeves of the SEC? I mean, it seems like it's open-ended.
Do you want to?
Yeah, I mean, I'm not familiar with the nature of the relationships between the enforcement. You're asking more from an enforcement perspective or from a compliance perspective than from the rulemaking perspective?
I'm just saying, if one sees something going on bad that is the purvey of the other person, can they do anything under Dodd-Frank, or is it just not able to be done?
I think there are a few provisions that for products that are under dual jurisdiction where either regulator can take enforcement action. Part of the problem is the way they've divided up the OTC derivative market. If it's a security-based swap, it's under the SEC and the regulation for security-based swap dealers or swap participants. If it's a regular swap, not a security-based swap, then it's under CFTC jurisdiction. There are some things that are mixed, and those are like for I think I can't remember offhand what the lists are, but those are subject to dual jurisdiction. But I think otherwise, it's each entity is supposed to trade, and you could have dually registered entities. My assumption is that they'll split it out by entity. And they can certainly share information. I don't know if they can take unilateral action without the consent of the other agency.
I would say that if this process were rational, we would have seen CFTC and SEC merged into a single entity. I think it's a clear indicator of how irrational the political process is that didn't happen.
I just had a question about Glass-Steagall, and as I recall, Glass-Steagall prohibited banks from buying securities from their own account. To what extent does that differ from the Volcker Rule, and could the compliance and enforcement methods used, I think that was section 16 of Glass-Steagall, in what way could those enforcement methods be used for the Volcker Rule?
Well, I mean, the issue with Glass-Steagall was that while the banks themselves were prohibited from engaging in proprietary trading, you could affiliate with others as long as they weren't principally engaged in proprietary trading, and that's the affiliation that was undone by Gramm-Leach-Bliley. So the idea is most proprietary trading still is done through affiliates within the bank holding company structure as opposed to by the depository institution itself. And then the question is, how much proprietary trading do you want to permit the affiliates to do? So the provisions that govern the ability of the banks, the depository institutions themselves, to engage in proprietary trading are still enforced post-Gramm-Leach-Bliley. It's the enhanced ability to affiliate with others that engage in proprietary trading that was the issue. Is that the...
Can I add something to that?
Sure.
I think maybe another way of also responding to that is that Volcker does not go as far as GLB does, because Volcker still permits securities operations so long as it is a permitted activity, including so-called market making. I shouldn't say so-called market making matters. And so it's not a outright ban on it. It's looking at the purpose for which you hold those securities in your book. Are you holding them to make a liquid market for a customer where there's a legitimate market and there are customers who are interested in purchasing it? And are you just making money on the spread, or are you actually trying to trade for your own account and take a position to profit? And so there's a big difference, because it does not, it just sort of going back to at least Paul Volcker's intent was you can't have your cake and eat it too. If you're going to have the safety net of deposit insurance and cheap money from the Fed, then you make that choice, and when you make that choice, then you can't engage in what he considered high-risk proprietary trading or hedge funds. Of course, as we've heard, that was substantially watered down and perhaps ill-advised from the outset because of the lack of universally accepted understanding of the difference between the permissible category and the impermissible one. So the question was, and it's a very, very interesting comment. The question is, historically bank regulators try to work behind the scenes to improve safety and soundness, and yet the stress tests seem in part to be designed to let the investing public or the public feel confident in the banking system. And so now there is this disclosure of the results. And so maybe that's part of one of the reasons why these tests aren't as strong as they need to be, because there's this sort of trade-off. We're not going to say this bank is about to fail in 2 seconds, because that would obviously cause a failure. So there's a little, perhaps some of the smoke and mirrors comes from the fact that they don't really want to shine a light. And so that leads us to the question of why have any kind of of disclosure of these tests. And if you look at the proposed rulemaking for this 165 and 166, which is together, there's an additional number of stress tests required. And I imagine industry will say, we don't want to disclose, and that's going to be one of the debates there.
I'm interested in the gap that the regulatory gap that seems to exist still between the commodities and the securities markets. My understanding of what's happened at MF Global is that it went through securities resolution rather than commodities resolution, and that resulted in the customer trading accounts in the commodities part of the firm not being protected. And we also have an enormous amount of money in ETFs, for example, precious metals ETFs, and they're sort of exempt from securities rules, but the same banks that you're talking about being too big to fail are holding enormous stores of gold and silver in the capacity as custodians for the ETFs, and then taking short positions. So, does Dodd-Frank affect any of these problems at all?
I'll start with the resolution, and then maybe some of the others can pick up on the rest. It still remains the case, and this wasn't unique to MF Global, that first off, right. There is insurance, SIPC insurance for securities accounts, but there isn't for commodities accounts, and that's always been the case. And it's also actually always been the case that in a combined broker-dealer like that usually it gets resolved under the SIPC process, not the commodities process. So usually only pure commodities brokers go under the commodities resolution process. Essentially, there has been no change to that. Other than if OLA had been invoked, I guess FDIC could have taken some of the broker assets and put them into a bridge bank, but that wouldn't have really solved the problem of having a shortfall of customer property and not having the insurance system for customer accounts on the commodities side of the equation.
I mean, I can just briefly add, years ago when we were talking about security futures products, which were supposed to be these joint products that could be traded in either a futures account or a securities account, one of the issues is, where do you hold it? Do you hold it in a securities account where you have SIPA protection, but you don't have express coverage for futures contracts or options on futures contracts, or do you hold them in a futures account? At the time, the staff became comfortable with the idea of holding futures products in a securities account on the theory that even if they weren't picked up by SIPC insurance, most of the time these accounts would be transferred to another firm long before liquidation became an issue. Now, obviously, when you have a failure like MF Global, those things are put to the test. But the hope was always that you could move these accounts out of the firm before liquidation was necessary and just find somebody else to buy the accounts. So a lot of these issues were there, they were identified but unaddressed.
And just one little slice of that, ETFs, exchange-traded funds, would be regulated as investment companies under the Investment Company Act. I'm not exactly sure, unless they were private funds. So I'm not sure what specifically, where that's intersecting with this question of insolvency, but they're not unregulated.
I think we have time for one more question. There being none, we're adjourned.